What is a force majeure clause in business contracts? Imagine signing a contract for a big project, and suddenly a hurricane hits or a government bans exports. What happens then? That's where a force majeure clause comes into play. It's a special part of a contract that helps protect both sides when unexpected events make fulfilling the agreement impossible or very difficult. These events are usually things no one could control, like natural disasters, wars, government actions, or pandemics. A force majeure clause acts as a safety net. It says that if something truly extraordinary happens, the affected party can delay or even stop their obligations without facing penalties or breach of contract claims. It's sometimes called an act of God clause because it covers events beyond human control. The clause is based on the idea that no one should be held responsible for events they cannot prevent or predict. Key parts of a force majeure clause include a list of specific events that trigger it. For example, floods, earthquakes, or government embargoes might be listed. The clause also requires the party affected to give proper notice to the other side, explaining what happened and how it impacts the contract. They must also try to reduce the impact by taking reasonable steps to fix or avoid the problem. From a legal point of view, force majeure clauses are important because they give clear rules on what happens when things go wrong. Unlike general legal ideas like impossibility or frustration, these clauses specify which events qualify and how to handle them. This helps avoid disputes and confusion during crises. In practice, a force majeure clause allows businesses to pause or delay their duties when an event occurs. It can even lead to contract termination if the event makes it impossible to continue permanently. But it does not automatically mean the contract ends unless the clause states so. It's essential to understand the exact wording because courts look at the specific language used. Some courts requiring the event to be explicitly listed, while others interpret the clause more broadly. When drafting or reviewing contracts, businesses should carefully define what counts as a force majeure event, include procedures for notice and mitigation, and consider how the clause interacts with deadlines or damages. Knowing these details helps manage risks and avoid costly legal fights if unforeseen events happen.